The rapid integration of technology into the dispute resolution process is reshaping arbitration, making it more efficient and accessible to the needs of the 21st century. How is DIAC future-proofing itself to not only stay ahead of the curve in response to shifting global dynamics, but also ensuring its continued leadership?
It is clear that we are in a cost and time-conscious era, but also in the environmentally and sustainability era, meaning that where technology plays a role, it is actually exactly in that concept. And remote hearings, remote case management conferences are absolutely standard. Remote case management conferences are so much the standard than if one would suggest to have in an international arbitration an in personam case management conference, the very first one at the beginning of the arbitration, it would be an oddity. With regard to remote hearings, we are saving a lot of cost and time by actually having even an in personam evidentiary hearing, but maybe having a hybrid one where one witness suddenly falls ill or has travel restrictions to come to the hearing venue. In earlier days, we would potentially consider canceling even the hearing and postponing it for a later date. These are all positive aspects that technology has brought to us in the arbitration proceeding. It also, of course, is a big aid in terms of transfer of data, of information, of files. We don't courier lever arch files anymore. We barely print documents and data. It's all transferred on file transfer share files or otherwise through the cloud, and it is so much easier to access.
The most exciting part of how AI is evolving arbitration is that it will make it more accessible on a global scale. And especially because arbitration, and especially international arbitration, it's based on legal information coming from all over the world in many different languages that weren't accessible to most of the practitioners or to most of the users of arbitration before. And now technology, and especially AI, with its capacities to browse a vast amount of data in any languages, is making all this knowledge accessible at the fingerprint of everyone. And so I believe it will strongly improve the system as a whole, making more reliable for better justice. But then let's look at the core values of arbitration. The first of them is the freedom of parties to choose people in which they put their trust. They choose arbitrators, they choose institutions, counsel, and this core value of arbitration will stay exactly the same in the coming years. Even more, maybe now that technology is automating the non-intellectual or non-complicated task of the process, we will rely even more on the people that will make the decisions for dispute resolution. Then, of course, we go to arbitration because it's more efficient and because it's more confidential. And here again, technology won't change anything. It creates a few challenges because, especially for AI, the risk, the security risks are very important, and so parties, institutions need to pay even more attention to that. But basically, the core stays the same.
Our technology partnership with Opus 2 demonstrates our shared commitment to transform dispute prevention and resolution by delivering innovative arbitration solutions in cutting-edge hearing technology to our users. As part of the partnership, we've launched a state-of-the-art digital platform, DANA by DIAC, overhauling and consolidating the Centre's internal systems and processes. DANA better connects parties, legal practitioners, neutrals, and the case management team, and leverages Opus 2's technology infrastructure to elevate our user experience whilst ensuring scalability and cybersecurity. DANA centralizes e-filing, case registration, and allows our users to securely submit and access case documents in a single, organized environment. In addition to DANA, our partnership offers our users seamless access to Opus 2's advanced suite of integrated hearing technologies and services. With a new dynamic services request portal, parties and legal practitioners can book virtual hearings, shared electronic bundles, real-time transcription, and electronic presentation of evidence, and more. It's fair to say that the COVID-19 pandemic significantly accelerated innovation at arbitral institutions worldwide. There's been a digital transformation, with institutions rapidly adopting new technology and electronic systems and encouraging the use of platforms like Zoom and Microsoft Teams to conduct hearings remotely. Rules and procedures have been revisited to provide for the adoption of digital procedures, electronic signatures and digital awards, remote witness examination, virtual and hybrid proceedings, and to introduce emergency arbitration provisions.
Perhaps seeing to that we have the right people in the organization, and this is at all levels in the organization. So it's at board level, arbitration court level, and at the level of the administrative body, including the case management team. What this does is that it ensures that we have the people on board who have the right vision to the future and the means to make it happen. One other aspect, I think, is to ensure that we have a regulatory framework which is flexible enough to adjust to the future needs of dispute resolution. So, for example, this means having arbitral rules that are fit to handle all types of disputes, like the DIAC Arbitration Rules 2022. So they need to be fit to handle everything from a traditional construction dispute to arbitrations relating to space or to cryptocurrency or any of these emerging sort of industries and sectors. The third aspect, I think, is to ensure that we are staying at the forefront of technology, and this is something that is and is going to be a priority for us. The last aspect that I think I will mention is simply to stay in tune with the needs of our users and listen to what the end user needs. That is the only way that I think we will be able to future-proof our operations, and that is something that we are very actively doing at